Witness P-0495 is the second among 9 witnesses summoned to appear before Trial Chamber 5A in the Ruto and Sang trial. He was granted protective measures including a pseudonym, image and voice distortion, and private sessions for some part of his testimony. The witness is represented by James Njoroge Njuguna solely for the question of possible self-incrimination. He testified through video link from an undisclosed location in Kenya from 16th to 22nd September 2014. Answering questions from OTP trial lawyer Lucio Garcia, the witness said that in November 2012, OTP investigators presented to him 2 pre-written statements.
Do you remember how many pages each statement had?
I can't exactly remember.
So you were given 2 statements, and you said that you rejected statement. What exactly do you mean by that?
I say that I was given 2 statements, and I had to reject another one because it was not matching with the region I come from.
Okay. Are we to understand that you rejected one of the statements, one of the 2 statements that you're speaking about?
Yes, Your Honor. I rejected one because the locations mentioned was not matching with the location I'm coming from.
All right, so let's go back to the statement that was remaining. You said that you took 2 hours to read it. What did you do afterwards?
After reading the statement, I had to modify that statement to suit the investigators the way they want.
At the time, were you given a, just so we can understand, was it a typewritten statement or was it a statement that was handwritten?
The one I was given was one typed and another one handwritten.
He further said that he was approached by a third person prior to meeting the OTP investigators who told him to cooperate with the investigators and to sign the statement, and that he would be offered anything he needs in return. Looking at his statement now, the witness recanted most of it and said that it was not only that he did not provide any such information to the prosecution, but also that the information was false. In particular, he said he was never present at a meeting at William Ruto's home in Sugoi on 23rd December 2007, at the Brookside Dairy in Eldoret on 26th December 2007, and the statement was inaccurate about his activities between Election Day and the day the results were announced. At the prosecution's request, the chamber declared the witness hostile and has authorized Mr. Garcia to cross-examine the witness, to ask him leading questions, to explore discrepancies in his statements. Most of the cross-examination by the Office of the Prosecutor was conducted in private session. Mr. Ruto's defense counsel, David Hooper, referred to the witness statement to confirm that specific parts were not true. In particular, he mentioned Mr. Ruto's speech on 27th December 2007 at a rally at Kipchoge Stadium in Eldoret, and the meeting at his house in Sugoi the same day. He further referred to news reports and news articles which mentioned that Mr. Ruto and other Pentagon members were on that day campaigning in the Western Province. The witness agreed with the defense counsel's submissions. Trial Chamber 5A's presiding judge, Chile Ebo Osuji, further asked the prosecution's senior trial lawyer, Anton Steinberg, what the prosecution wants to do with this witness's testimony.
We have a witness on the stand who had been subpoenaed to appear, and on the basis, of course, of the statement the witness gave to you, implicating the accused in criminal conduct. Witness comes to the court, takes the stand the first time the prosecution mentions the statement. The witness says that everything that's in the statement was put in there effectively by an investigator and an OTP trial lawyer. You have vigorously cross-examined the witness, attacking his credibility, especially on that account. The Ruto defense in their cross-examination get up, they attack the witness's credibility on other accounts, and again, returns to the allegation made against the OTP. Mr. Hooper made it very clear on 2 occasions that the Ruto defense rejects the witness's testimony that it is the OTP effectively that put those material in the witness statement. They made it, Mr. Cooper said that quite clearly. They do not accept that from the witness. The question then becomes, what do you want to do with the testimony of this witness?
Your Honours, if I may speak to that point, this is a matter which I suspect will not be unique to this witness. The starting point in my respectful submission is that this and several other witnesses gave relevant and incriminating evidence upon which the prosecution relied, both in the confirmation hearing in certain circumstances, but certainly in drafting the charges which the accused currently face. The prosecution will argue that the reason why this witness and various other witnesses have ceased cooperation with it, and in many cases have recanted their evidence, as with this witness, is because in the intervening period between giving their original statements to the prosecution and being called to testify, they were subjected to improper influence, which has materially affected their cooperation with the prosecution. So the purpose, what do we do with this testimony, Your Honours? Your Honours, we submit that the Chamber takes into account this testimony, takes into account the transparently false and risible allegations that the witness has made against the OTP, which my learned friend has quite properly, and we thank him for that, quite properly rejected, and considers what then to make of the earlier statement. We say that the earlier statement should be admitted and should be considered by the Chamber.
Witness P-0495 concluded his testimony with a brief examination by Mr. Sang's defense counsel, Joseph Kipchumba Kigen-Katwa. Mr. Kigen-Katwa pointed out to the witness discrepancies between the screening notes from his interviews with the OTP and his witness statement. He specifically asked the witness about an extract from the statement referring to Mr. Sang speaking on Kass FM radio about an alleged rigging incident before the elections. The witness said that he hardly ever listened to the radio during the time of the events. The third prosecution witness summoned to appear, witness P-0516, started his testimony on Monday, 22nd September, and will continue this week. Can previous statements of the witnesses who recanted their testimony be admitted as evidence and considered by the judges when they decide on the guilt or innocence of the accused?
Previous statements of witnesses who recanted or changed their testimonies may be admitted as evidence only by the decision of the chamber. Judges may authorize the admission of previous statements if they consider that the admission is necessary to better assess the credibility of the witness, or to put any discrepancies with the witness's oral testimony in the right context, or as well as evidence for the truth of their content based on the criteria of relevance, reliability, and probative value. When making the final determination on the truthfulness of these statements, the judges will take into consideration several factors, including, for example, the existence of other evidence which corroborates these statements.